Hello, my name is Matt, and I am going to talk to you today about my favorite religion case of all time. I should say this is my favorite Supreme Court religion case. My favorite religion case of all time is actually a district court case, which I will talk about in perhaps another video. But this is my favorite Supreme Court religion case, and this is the case of the Church of the Lukumi Babalu Aye Incorporated versus the city of Hialeah. Now, if you're a fan of I Love Lucy, you might recognize something in the name of this case. That is right. The Babalu in this case is in fact the same Babalu as the title of the Desi Arnaz signature song, Babalu, which he performed many, many times on I Love Lucy. And so Babalu Aye is a deity of sorts in the Caribbean syncretic religious traditions, such as Santeria. Desi Arnaz was famously Cuban. He was Caribbean, and I don't think he wrote the song, but the song is actually, if you listen to it, it starts out with Babalu, 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 Aye. So the song is actually about a guy sort of beholding and invoking a statue of Babalu Aye and requesting various good fortune and favors from the associated entity. So now, if nothing else from this video, you know something about Desi Arnaz and I Love Lucy that you didn't know before, perhaps. But the case was not about I Love Lucy. It wasn't really even about Babalu Aye. The case was about animal sacrifice in the first instance. So the members of the Church of the Lukumi Babalu Aye were practitioners of Santeria. They are practitioners of Santeria. The church is still around as far as I know. And as part of the Santeria religion, they would sacrifice animals, small animals such as chickens, in their homes as part of their rituals and prayers and things like that. If you've ever seen the movie Devil's Advocate, there's a very exoticized sequence where Keanu Reeves' client is a practitioner of some unnamed syncretic Caribbean religion, Afro-Caribbean religion, I should say. This is very kind of spooky scene where he sacrifices a chicken as part of some ritual in his apartment, and then the following day, the prosecuting attorney has some sort of coughing fit and cannot complete the trial, and the guy wins. Keanu Reeves' client goes free. That's the sort of treatment that Santeria and these kinds of traditions get in popular culture. But nonetheless, there are actual practitioners of Santeria and voodoo and other sorts of folk religions from the Caribbean, and they engage in animal sacrifice, and that's okay, as far as I know, as far as I care. But in this case, the city of Hialeah did not like the fact that all these people were sacrificing animals in their city, so they passed a law saying there will be no ritual killings of animals in public or in private, except for the purposes of food consumption. And if you're wondering why they threw in that food consumption exception, it's because in Jewish law, for meat to be kosher, there are rituals associated with the slaughter of the animal from which the meat is coming, and the last thing any city in Florida is going to do is pass a law that looks askance at the Jewish population. So, but here, obviously, the Santeria population was a minority. They had no power, and the city was able to push through this ban on ritual sacrifice of animals. And what the members of the church and the church itself said is, that's bullcrap. You cannot outlaw our religious practices. We need to do this as part of our religion. You can't stop us from doing it. That infringes upon our free exercise of our religion against the Constitution. And the city's response to that was pretty reasonable. They basically said, look, we're not saying you can't sacrifice animals. We're saying nobody can sacrifice animals. You're just not allowed to ritualistically slaughter animals in your house. Nobody can do it. It's a law of general applicability, and laws of general applicability that apply to everybody. You can't get around them just by saying that your religion is infringed by the law. If you get a speeding ticket because you're late for church, you can't go to court and say, well, I would have broken my religious vow to go to church if I was driving the speed limit, and therefore you can't sue me you can't charge me for speeding. That's not going to work. It might work on the cop. It won't work on the judge. And that idea is pretty well established. It's very controversial. at least one Supreme Court case every year that seems to tease around the edges of that rule. But it goes back at least 30 years at this point to a case called Employment Division versus Smith, where a gentleman had got fired from his job for using peyote. He was a Native American guy, and as part of his Native American religious practices, he used peyote, and he got fired because he violated the company's drug policy. So then he applied for unemployment, and the Unemployment Division of Oregon said, no, we're not giving you unemployment because you got fired for a reason. You broke the law and you were doing illegal drugs. And the Supreme Court held, in a opinion by Justice Scalia, of all people, held that no, this is fine. It's a law of general applicability. Nobody can use peyote. You can't come in and say, well, my religion tells me that I get to use peyote, so that means I get to use peyote. That's not how it works. So that's the argument that the city made in the Church of the Lukumi Babalu Aye case, and it didn't work because something different was happening here. It wasn't that there was some law pre-existing that said you can't sacrifice animals in your house, and then the church members came in and started making sacrifices and demanded an exception. No. It was okay to kill animals in your house and kill animals in public ritualistically until the Church of the Lukumi Babalu Aye started doing it, and then the city got mad at them and passed a law specifically directed at that church to make them stop. Even though the wording of the law applied to everybody, the intent behind the law was to target this particular religious group, and that was not okay. It was a solution in search of a problem, and then the problem was a particular religious group's religious practices that did not pass muster at the Supreme Court. The Supreme Court struck down the city of Hialeah's law, and it was a very bad day for the chickens of Hialeah. Now, the reason I like this case so much is because this isn't really a case about government restricting religious practice. It's a case about the government's attitude toward religion. Again, if there had been a pre-existing law against killing animals, and the church had come along and said, we want to kill animals, the Supreme Court probably would have sided with the city under the Smith case, saying, well, no, if you have a law of general applicability and there's some reason for it, I mean, obviously, keeping animals from getting killed unnecessarily is something that the state can do. There's no religious exemption guaranteed to that, but because the only reason this law existed was because the city got mad, got tired of these particular religionists practicing a particular religious ritual, that was enough for the court to say, no, the government is targeting this religious group, and that's not okay. And that is an issue that actually comes up not infrequently at this point, including in a case I'm not going to call it one of my favorite cases. I'll get in a lot of trouble if I say that. I find this to be a very interesting case, and I agree with the principle elucidated in the case, even if I don't agree with the result or necessarily the facts, and I will explain all of this to minimize the number of people who get mad at me. But I'm now going to talk about the Masterpiece Cake Shop case, which is the gay wedding case from a few years ago. Now, I'm in Colorado. I know people who work and have worked in the Colorado AG's office that were involved in this case. They're very good people and very good lawyers. Ultimately, but this is obviously a big deal around here. So for those of you who may not be familiar with what I'm talking about, this was the case where the baker refused to bake a cake for a gay wedding, citing his personal religious beliefs that gay marriage is wrong. He was punished in some way, I don't remember how, by the Colorado Commission on Civil Rights. He had argued that my religious beliefs excuse me from having to make a cake for a ritual that I don't agree with. And the Colorado state government disagreed with him and went all the way to the Supreme Court, and the guy won. And here's where almost everybody who talks about this case gets it wrong. The Supreme Court did not say that you can refuse to serve gay customers based on your religious beliefs. The Supreme Court emphatically did not say that. That's what everybody was that was the question everybody was hoping they would answer, but they didn't answer it. What the Supreme Court actually found in that case, in a very unsatisfying opinion to people who aren't like me, was that the Colorado state government was disrespectful of the baker's religious beliefs in the course of prosecuting his case and evaluating his claims. Now, if you go back and look at the underlying proceedings, I don't think that's true. I think they were sufficiently respectful of his religious beliefs. If you go and look at the transcript that even the Supreme Court cited, I don't think it rises to the level of, say, sorry, I just got an alert. Still recording? Yes, I am. It doesn't rise to the level of City of Hialeah saying all these wacky Afro-Caribbeans are killing chickens in their apartments. Let's pass a law against them. But the basic principle in Masterpiece Cake Shop is, regardless of the substance of your issue with somebody flouting possibly the law based on religious beliefs, you have to be nice about it when you're sort of bringing down the hammer on them and making them follow the law. So, and that principle I agree with. I don't think anybody wants the government being disrespectful of religious beliefs. I shouldn't say anybody. There are plenty of people who would love that, and I can name names. But I think normal people are okay with the government just being respectful of people's religions, even if they don't agree that they're using their religion properly to get around laws. And that principle actually got a 7-2 ruling, with Breyer and Kagan, not exactly theocrats, joining the Kennedy and the conservatives to find that. The only dissents were Ginsburg and Sotomayor. Anyway, the point is that the Lukumi Babalu Aye case, I think, is a good example of how the ultimate substantive question of whether somebody's religious beliefs excuse them from complying with the law is not just about the effect of the law on the religious belief or the seriousness of the religious belief. The sort of attitude and orientation and respect and deference on the part of the government when dealing with these issues is also very important. So that's my favorite religion case. I think the principle is good. I think the facts are interesting. I think the I Love Lucy connection is really cool. And I have to say that when I do my elementary school Constitution Day presentations, the kids always ask me what my favorite case is, and I always say that, and they're always very impressed that I can just pronounce that off the top of my head, and I think that it's a very cool, interesting thing to just be able to say. So, Church of the Lukumi Babalu Aye versus City of Hialeah, that is my favorite religion case. Thank you.